The American legal system is a part of the common law tradition, as it is in most English-speaking countries. The term common law is used here in the sense that it distinguishes it from modern civil law, Roman law, other systems of law. Common law may be defined as that body of law and juristic theory which was originally developed and formulated and is administered in England as well as now in all the United States and people of Anglo-Saxon stock. Very early in the history of English law, the decisions of the court were considered precedents. Such precedents were interpreted as furnishing examples or authority when considering an identical or a similar case. If a case occurs subsequently which has the same questions of law, then the precedent will be used. And therefore the stare decisis was developed. What it means is when a court has set a precedent which is applicable to a certain set of standards, then the court will adhere to those set of standards and then will apply them to other cases with the same type of facts and circumstances. Thus, under the doctrine of stare decisis, the decisions of the court embodied in the law is what is referred to as case law. And this should be differentiated from statutory law. A statute is an act of the legislature that commands or prohibits something. And in addition to the statutes, we have the constitutions, both federal and state constitutions. Under our federal constitution, each state is a sovereign state, except for those powers delegated to the federal government. This means that there is not one legal system in this country, but in fact 51. The primary authorities of the law are the common law, statutory law, and the constitutions. All other written expressions of the law are secondary authority. For example, digest of case law, treatises, encyclopedias, and loose-leaf services and reporters. Now, primary sources of law are mandatory or persuasive. What is the difference? The mandatory ones are those in the state where the case is involved. If no law can be located in that particular state, then the attorney may focus his search on court decisions of other common law jurisdictions. That is called persuasive primary authority. Now, if the legal search proves fruitless in the primary category, then the researcher would look for secondary authority. And secondary authority would be books, treatises, encyclopedias, and so on. Presently, with the aid of computer technology, the search for cases has become less cumbersome. In the past, it had to be done virtually manual. Now, after finding the law, the attorney should determine which court the case should be tried in. Remember that most cases are actually settled before trial. This is done by informal bargaining and compromise among the various people involved, the attorneys for the defense and the attorneys for the plaintiff. Otherwise, a suit is filed in court, and the suit can be brought either in state court or federal court. And the lawyer has to determine in which court the case can be tried. Now, one checks the statutes to determine where to try the case, that is, which court has jurisdiction. And the next thing that needs to be found out is which county the case should be tried in. This is called venue, the location, the place where the trial court would hear the case. Well, how does the attorney commence a legal action? The plaintiff, through his or her attorney, files a complaint or a petition, and a summons is also filed with the complaint or the petition. And this is served to the defendant by the sheriff, stating that the defendant has been sued by the plaintiff and that the defendant is directed to file a written answer to the attached petition. Now, within a period of approximately 1 month, the answer should be given. Of course, an extension could be requested, and that can be approved by the judge for good cause. Now, the answer may be a mere denial of the charges. On the other hand, it may include a number of defenses or even counter charges. Now, what about the period between the answer and the trial? That period between the answer and the trial is the period of discovery. Discovery is the means to determine what the parties have and find out relevant and non-privileged information. This allows the parties on both sides to find out, to discover relevant material. And of course, that is done with the approval of the judge. And the things that are used include interrogatories, depositions, and requests for admissions. And now let us talk about the deposition. It is a tool. It is a formal legal procedure during which the opposing attorney will ask questions in an informal setting. The setting of the deposition is usually at the doctor's office. The lawyers and the court reporter are present, and it is important to remember that the individual who is being deposed is the witness and is under oath. And of course, depending on what you say and the answers that are given by the witness will be studied by the opposing attorney, and it is important to avoid being foolish. Otherwise, those will be used against you in future proceedings. Remember, the lawyers are especially trained in these procedures. You, as the healthcare provider, the doctor, the nurse, are on unfamiliar grounds. The setting of the deposition, even though it's informal, it is important that you be on guard. Now, the first thing that you need to remember is not to volunteer information. If you are asked the question, why, then answer only that question specifically and say no more than what you are asked. Remember not to volunteer information. Once you volunteer information, then you are required to tell the rest of the story. Answer only the question that you are asked. Answer it short and listen. If the attorney wants additional information, let him or her ask you another question, and then you answer appropriately. Listen to the question. If you listen to the question, you will be able to answer only what is asked. Remember again, no volunteering. To do that, pause. Pause after an answer. After a question, this will give you a chance to think and will give your attorney a chance to object in case the form of the question is improper. Sometimes a good attorney would try to put in your mind or try to trick you and ask you a double-barreled question. The classic example of such a question, have you stopped beating your wife yet? If you say yes, it means you are beating her sometime in the past. If you say no, then you did beat her. So listen to the question. And such a tricky question, it comes usually without your noticing it. It creeps up on you. So stop, pause, listen, and ask for an explanation. With the pause, you are able to think about the meaning of some of the words that are being asked of you in the question. And don't hesitate to ask for clarification or merely a clearer question. You don't have to answer the question that you are asked. The least you would expect from the attorney is a simple question. No tricky things. And if you are asked a question that can be answered in 2 different ways and you really don't know which way to answer, then don't provide an answer based on your interpretation of the question. Wait, ask for the clarification, and then answer the question. Particularly if a word is bothering you in the question, ask for the meaning of that word. Ask the attorney to simply explain what that word means. And if there are problems that you think you are going to face during the deposition, please take time to spend with your attorney ahead of time to ask questions as to how you should answer them. Be open with your attorney. And then when you answer the attorney who is asking you the question, then be honest. Do not embroider your testimony. If you do not know, or if you cannot remember the answer to a particular question from your own personal knowledge, then don't answer it. Tell him you don't remember. Remember, if you say something during the deposition that is false, dishonest, your credibility is going to be on the line during the trial. And remember that you are under oath. You must testify as to what you know of personal knowledge. And honesty is always the best of all policies. And always pause before you answer the question. This will help you to be in control, particularly when you become a little bit nervous and perturbed. So as a health care provider, doctor, nurse, you are considered an expert witness under certain circumstances. But first, let us talk about the witness. The witness is an individual that is under oath to testify. What is an expert? The expert is the individual who has a peculiar knowledge, particularly scientific, and in our case we are dealing with medical knowledge. Medical science is certainly an art and a skill, and it is important that the individual who is testifying be well versed with the area that the expert will testify on. Now, the expert medical witness has had a special opportunity for observation of medical knowledge and skill, and then he or she is able to obtain the medical facts and deduce correct inferences from the facts that are presented to the expert witness. Now, the judge determines who is a competent expert medical witness. The expert medical witness is a formidable individual. He is a particularly strong individual because he has both the judge and the attorney on the side of the expert witness to rescue him or her in the event of unfair tactics by the opposing attorney. Indeed, most cross-examiners regard the medical expert witness with some trepidation. On the other hand, the cross-examining attorney will go for the inept, the unprepared, unpossessing, unthinking medical expert witness. Now, as an expert witness, avoid exaggerating your qualifications. Avoid memorization. But be sure to remember what you had read. And do not use medical terminology. You need to speak to the jury in English words. Act like a dignitary. Sit up straight. Look competent, comfortable, and be honorable, and most certainly be credible and keep your cool. Avoid extremes in criticizing other expert medical witnesses. Now, why does one need to go to court? Is the fact witness who needs to go to court because he or she treated the patient involved in the lawsuit. Or you may have knowledge that may be pertinent to the case. Now, in contrast with the fact witness, the expert medical witness may or may not need to go to court. The expert medical witness may serve merely as a consultant and not appear in court. The expert's remarks there of the consultant are protected. They need not be exposed to the opposing attorney. On the other hand, the expert witness who will appear in court should remember a few things. The opposing attorney has a right to obtain the name, the opinion, and the basis of the opinion of the expert witness. And it is important, therefore, that the expert witness make sure that the case is supported solidly by the medical facts before accepting the case. Otherwise, he or she should decline the case. They should not accept a case that is marginal. Now, the expert witness helps the court and the jury to reach a decision on the case. And the expert medical opinion should be therefore based on the facts as well as on observations of similar cases by the expert medical witness. Now, whether you are a fact or an expert medical witness, it is very important to prepare. Lack of the right kind of preparation could be the most damaging thing to an expert witness on the stand. Next thing, examine the patient if at all possible. And if it is also possible, do follow-up examinations and insist on preparation for your testimony. That can be done with your attorney before coming to trial. Also, inquire as to what you would expect on cross-examination by the opposing attorney. For example, the opposing attorney may say, "And you talked to your attorney about the testimony?" Your answer, "Yes, we talked about the matter involved and how we could clearly present it to the jury." Play the role of a teacher. Remember, the teacher is trying to enlighten the jury about the difficult facts in the case. And how you present the case will depend how you marshal the facts and what ideas you can present. You could work with questions and answers, read all medical pertinent documents that are relevant to the case, review recent medical literature, and do not overlook the exceptions where authorities would disagree with you. And if you've never visited the courthouse, take a few minutes to visit it. See where things are. It will relieve you and make you more at ease. And just before you appear in court, you could relieve your mind and be less anxious. You remember when we talked about the deposition earlier, we talked about an informal setting, away from the courtroom. But your testimony then was under oath. And your testimony then was dealing with the facts as they will be discussed here in court. And the purpose of the deposition then, remember, was to acquaint both sides with your opinion and what you said, and to prepare rebuttals and to prepare all the testimony for the case. Now, at trial, the deposition may be used to impeach the expert witness who says one thing at the deposition and another thing in court. So read your deposition before you come to court and take that deposition very seriously and avoid wisecracks. Now, let us talk about the expert witness fee. As an expert medical witness, you should settle matters relating to the fees with the attorney concerned before going to court. Now, in some state, the law requires a medical witness to testify under certain circumstances for a minimal fee. A fact witness is technically entitled to the basic witness fee, although that may be negotiated. But an opinion witness who is an expert can set his or her own fees. If the attorney does not raise the question of fees, the expert medical witness is entitled to raise the question and settle it ahead of time. If asked, what are you being paid for testifying? The answer should not be $500, but rather that you are being paid nothing for the testimony. You are being paid for your time, your professional knowledge, and your services in studying the medical facts in this case, and for your medical expert opinion based on those facts. It is best for an expert witness in general to compute his or her time on an hourly basis rather than a lump sum fee. The hourly rate may include not only the time of appearance in court, but also the time spent in making out reports, in various conferences, during the performance of the research, or during the testimony and depositions, appearances in court. Expenses should also include costs for hotel rooms, meals, tips, and time spent on the telephone and other conversations and consultations. Be sure to keep an account of the time spent, and it is important to have documentation. Now, it is unethical for an expert witness to enter into any agreement that makes his pay dependent on the outcome or contingent on the outcome of the case. But the witness can serve without guarantees of payment. And in case of contingency, if that is brought up, it is important to mention that there is no such agreement. Whether the case is won or lost, you will be paid. However, you do have some patients that do not necessarily pay you, but you expect to be paid. Now, some attorneys will ask you about the amount of time that you have spent in an attempt to add up the hours and try to show that you have accumulated such a horrendous amount of money. Now, if that is being asked, then tell the attorney that you are going to be paid depending how long he will keep you in court. And in case a settlement is achieved, there should be an agreement how you will be paid as well. Now, at times, an attorney may be willing to advance some money towards the fee. That will be a retainer, which will be credited to the future payments for services rendered by you. Now, the route to the stand. Be prompt. Arrive on time. Be sure to know when you're supposed to arrive in court, and also be sure to know where you're supposed to sit and wait. And then when you enter the route to the stand, the first impression to the jury is a very important one. The expert medical witness should have that in mind when he arrives at the courthouse. While waiting to be called to the stand, do not discuss the case with anyone. The call to the stand should raise your level of adrenaline, but to ward off stage fright, walk at a steady pace, not fast, not slow, and keep your eyes on the clerk who is going to give you the oath. Place your hand on the Bible and raise your right hand straight. And remember to keep looking at the clerk straight in the eyes, and when he finishes the oath, you say, "I do," in a clear voice that can be heard by the jury. After all, the jury wants to hear you. And then take the stand. You should sit up straight and put your feet firmly on the floor. Put your hands loosely. You don't need to slump. Sit properly. This is another moment when the jury is sizing you up. Remember to wear an attire that is appropriate. You don't need to be flashy, and you don't need to be wearing clothes that don't look nice. Be comfortable. And you need to project well enough so the jurors can hear you. And there is a system also to raise your voice if you need to be heard better. Now, don't puff up your qualifications, and yet you don't need to be falsely modest either. You need to mention about your board certification, about your awards, and that will be done when you are asked questions relating to those. But don't go overboard and mention the last trophy that you obtained from your recent golf tournament in the Bahamas. Now, the first set of questions is the direct examination. Take your time while answering questions. Don't be a too willing witness, and yet don't drag things too long. Lawyers hold that there are two types of particularly bad witnesses: the one who is overly willing and the one who is extremely reluctant. Now, be brief. Answer the questions only. Do not volunteer. Do not go over too many explanations unless you're asked. And certainly don't talk about insurance, because that will be grounds for mistrial. Try to avoid using words as perhaps, I suppose, it seems that, or indications are. It is best to be specific. Otherwise, the jury may get the impression that the expert witness is not sure of himself or herself. And similarly, avoid the phrases, I honestly believe, or to tell you the truth, which may not enhance the witness's credibility but may create an air of suspicion. Your testimony is best strengthened by using some demonstrations. Avoid using technical words on the witness stand. Use simple English. And if you do use medical terms, explain them again in plain English to the jury. If a question is not clearly phrased, do not hesitate to ask that question again and ask for a clarification. And if the attorney makes a remark that is not completely correct, then you should correct the attorney. Now, when asked to render an opinion as an expert witness based on a series of assumptions, this will be called a hypothetical question, and it must conform to the facts that are substantiated in the evidence of the case. So the question must contain those facts that will allow you to formulate an opinion. You must resist attempts by the lawyer to omit pertinent facts or load the questions with irrelevancy. This necessarily implies that the expert witness should come to court with proper preparation and full knowledge of the facts in the medical record. Now, a few words about the medical record. The office medical records, or for that matter, hospital records, should include only relevant comments. Irrelevant comments may be potentially dangerous, particularly if they are placed in the record. When an expert witness uses his or her medical records in order to refresh one's memory on the witness stand, they become a part of the evidence. Therefore, the opposing attorney can examine the records, comment on them, or read from them. It is therefore unwise to include in the records anything that you would not want to be read in court. Messy records are a great source of irritation and frustration. If the records are kept carelessly, then the jury may think that the expert witness himself or herself is careless in other ways. Now, never alter the medical records. Go over them just before appearing in court. The doctor should initial any entries in the record that have not been initialed by him, and a small checklist of the medical records should comprise the dates, the source of the patient's illness, nature of the complaint, results of examinations and diagnosis, and of course treatment, prognosis, and financial data. It is important to define correctly what you take with you to the stand, because what you use it to refresh your memory, it will be used and examined by the opposing witness. Now, what about demonstrations? If you use demonstrations, use the most effective techniques. The power of illustration cannot be underestimated. Exhibits should be nicely displayed to the jury. X-rays should be enlarged and try to clarify the testimony that you are presenting. Otherwise, the testimony will be very confusing to the jury. The expert witness is permitted to indulge in what is called showmanship. Exhibits can vary from, as I said before, X-rays or custom-made drawings by professional artists, and those could be presented for explanation. The jury is actually fascinated by medical exhibits which show the functions of the human body. You must face the jury and address it directly. Use gestures. Use pointers when you are discussing exhibits. Try to move about a little bit. You don't have to stand still in one place. Use words that the layman would comprehend. Use the blackboard or the screen if it will serve your purposes to demonstrate what you are attempting to show. Therefore, the exhibits will be most helpful to you. Now let us turn to the demeanor. You remember, the judge is the boss in the court. You should always be respectful. And when the witness needs to address the judge, then he would be able to ask the judge the question. There are 3 instances when the witness may address the judge. First, if the judge asks the witness a question. Second, if the attorney asks the witness a question that might be privileged, and the witness is entitled to check with the judge to determine whether or not to answer the question. And the third instance, if the witness is concerned that he or she has been cornered by the cross-examiner and there is a demand for a yes or no question, and the witness does not feel that such an answer would be adequate, then you as an expert witness may turn to the judge and tell him so. Usually the judge would allow a fuller question and answer. But if he does not, don't argue with the judge. Just simply answer the question to the best of your ability. Remember, the lawyer on your side can have you bring out the whole story on redirect examination. As to the jury, be considerate, courteous, and do not use words that are caustic, particularly when talking about private matters. For example, when talking about private organs. And do not stare at the jury. Remember to address yourself to the jury when the question involves explanation, or in the exhibit, or in the demonstrations. Now, information may be confidential or privileged. Confidential information pertains to the expert witness's ethical duty to keep secret most of the information that he or she might have obtained while attending a patient in a professional capacity. Confidential information becomes privileged only if state law provides that it cannot be divulged in legal proceedings without the patient's consent. If a professional, therefore, is asked a question that he knows should not be answered, one can say, I ask to be excused from answering the question because the answer would violate my patient's confidence and invade the doctor-patient privilege. Or one might turn to the judge and say, Your Honor, I doubt I should answer this question. I believe it involves the confidential communication between doctor and patient. If the judge makes a decision, it is best to accept his ruling. Remember The privilege is to protect the patient and is not a right of the doctor. Therefore, if the patient waives the privilege, the expert medical witness must testify as to relevant materials in that case. And of course, you should get the consent and waiver of privilege in writing. The waiver should be signed by the patient and should be explicit and all-inclusive. Now, if the patient tells a professional, such as a physician, certain matters that are not relevant to the diagnosis or treatment, then that information cannot be privileged. Similarly, when an insurance company employee and the doctor is asked to examine the patient for the insurance company, there is no doctor-patient relationship, and the information obtained is not privileged. Again, when an individual is examined for physical fitness or for certain work to determine his or her eligibility for pension, or when he is applying for insurance policies, there is no privilege because there is no treatment. As to confidentiality, one can divulge the number of visits and the dates the individual saw the doctor, but no mention should be made of the diagnosis or treatment because those two are confidential. However, there is no unanimity with respect to the fine line between privileged and non-privileged and confidential matters. Next is the cross-examination. The attorney for the other side is the cross-examiner. The cross-examiner, who comes on strong, should put the expert witness on alert to keep cool no matter how hot the witness seat becomes. The expert witness may challenge any question that may contain misrepresentation or falsehood. Under no circumstances should the expert witness let himself or herself be provoked to counterattack. This is very important because one must retain the dignity and remain resilient. That will be more than adequate to put the brow-beating lawyer in his or her place. Now, as an expert witness, avoid leaving yourself for a backlash because you may be in trouble. Beware of the cross-examiner who does not appear tough at all. When a cross-examiner comes on in a very friendly fashion, do not lower your guard. Instead, raise it and open your ears and listen very carefully. Be careful of the word speculation, because the cross-examiner needs you to agree that your opinion may be a speculation, and that will mean guesswork. If the word speculation is mentioned as to your opinion, be sure to disagree and say that your opinion is based upon reasonable medical certainty and in accordance with scientific probability. That's reasonable medical certainty and in accordance with scientific probability. One type of a cross-examiner specializes in silence threats and approaches the witness stand while grimly shuffling a batch of papers. He is attempting to frighten you into thinking that such papers contain damaging evidence. Similarly, avoid being impressed by the opposing attorney who writes down some of your responses in a very obvious manner, perhaps attempting to suggest that he is going to let you eat your own words. Crying Dan is the name given to the lawyer from San Francisco who goes in for noisy histrionics and tries to stimulate disbelief, amazement, indignation, outrage while cross-examining an expert witness. Never get angry or lose your temper under cross-examination. Otherwise, you become a careless expert witness. Do not change your demeanor or tone of voice when you go from direct to cross-examination. Avoid any arrangement with your lawyer to develop a signaling system between the two of you while you are on the witness stand, because a good attorney will quickly spot and exploit such an arrangement, thereby making the expert witness on the stand seem a conspirator avoid disparaging the testimony of the opposing expert witness also. This job is for the lawyer to handle the other expert witness. And you could answer by saying, I'm sure Dr. So-and-so is a competent medical professional, but I simply do not agree with him or her on this particular issue. Watch out for the attorney who turns away as though he has completed his or her cross-examination, and then he will relax, only to find that he will turn to you and ask you a question and say, just a moment, one more question. Remain on guard. Do not relax until the cross-examiner says, that is all, doctor or nurse. And then watch out for the cross-examiner who keeps asking question that requires a yes answer, and he's going rapidly, one question after another, and you're answering yes and yes and yes, and then he'll reach a question that needs a no, and because of the rhythm that has developed in saying yes, then you may end up saying yes when you're supposed to say no. Remain on guard. If the cross-examiner starts the question by saying, it's a fact, and you know it's not, be sure to say that at once. Always remember that when you are at the witness stand, you should not lose fact that you are the expert witness. You are the expert witness. And now let's talk about the grand finale. Do not leave the witness stand until you are asked to do so by the judge. Maintain your dignity. Do not make an obvious victory sign or a sigh of relief or a broad grin of triumph or run away from the stand with unseemly haste. The jury will continue to size you up until you are out of the courtroom.